Justice must not only be honest and truthful, it must be balanced.
Asking you to weigh in on the whole matter of the passage of the right for the prosecution to appeal certain rulings.
Well, certainly, over the last 15 years, prior to even my tenure, I know previous DPPs, that has been a critical concern of theirs, and I am just happy that we had the broad back and the fortitude to continue the advocacy. We too have sent submissions on several occasions to the Ministry of Justice, and I have noted where it is in the legislative process, and I'm very heartened by the fact that at last it seems to be here with us. I listened to what the Chief Justice had to say, and I was very moved to hear that our Chief Judicial Officer, as a matter of principle and law, is signifying in the public domain, and he has done it before, his great embrace of what is a natural part of the evolutionary process of our jurisprudence, which recognizes not only the rights of the accused, but in terms of equity and balance, the rights of the victims and the witnesses is of equal importance.
Bills were presented to me based on the submissions from the last administration sometime in 2016, and when it came before me, my natural inclination as a defense attorney, no, this is breaching double jeopardy. Remove it from legislation committee. I don't support the double jeopardy, the breach of the double jeopardy. Order first acquit must be firm. And it remained in the Ministry of Justice, however. And I did read Patrick Robbins's lecture at the UTEC. I started to think that justice must not only be honest and truthful, it must be balanced. And it cannot be that when a judge makes an error, and judges make errors. I have been the beneficiary of many appeals in the Court of Appeal of judges who made errors in summing up. And I have had many clients who have been acquitted because of the errors that judges made in summing up.
When examining the 309 cases that were disposed of in the Circuit Court in 2019, 92 of them were based on no evidence that was submitted by the prosecution. So do you believe then that more emphasis should be made on improving the quality of submissions?
Well, listen, you see, it is very unfortunate, perhaps because you're not a criminal lawyer who practices in the Court of Appeal. Let me make it quite clear. The right of appeal, whether for the prosecution, doesn't have anything to do with what is going to happen by the prosecution down below. It has to do with an issue where there is judicial error. If there is judicial error, in the same way that if it goes to the Court of Appeal at the behest of the defendant, that's the person who was convicted, the conviction can be quashed and a retrial ordered. So in the same way, if there is judicial error, where, for example, no case to answer was upheld as a matter of law, when in reality that was an error of law by the judge, then we should be able to appeal that. Because if the judge makes an error and upholds no case to answer, then it means that that would lead to an acquittal. So the right of appeal, I mean, and I say to the greatest of respect, these are technical areas. No matter what a police officer investigating a case or a prosecuting counsel prosecuting the case can do if a judge makes an error. So in other words, you are submitting case law on a particular point, and the judge in error either misinterprets the law, makes an error, and does not allow the matter to go on, and upholds, for example, a no case submission. then what the right of appeal would allow is for us to appeal, looking at it, and the Court of Appeal will say that was an error of law and the particular prosecution should be reinstituted.
Okay.
All right? So it has to really be made clear. And if you look at other jurisdictions, I mean, I know all the DPPs in the Caribbean, most of them, and if you look in the jurisdictions, this is a right which is not used often. We know that the burden is always on the prosecution to act at an even higher ethical standard than defense counsel. So, as my learned colleague in Belize, Mrs. Cheryl Vidal, indicated publicly recently on one of our local stations, that she really only makes an appeal on behalf of the prosecution if she's 100% sure that she's correct. Right? For example, the right of appeal in sentence, that is also very important because there too, a judge can make an error. So you have the poor victim, and this is a matter, for example, suppose murder, and the judge gives, we reduce the sentence to manslaughter, and the judge gives 6 years in a double manslaughter situation. That is outside the range, and it is so low that it would shock the public conscience. So if a judge gives a sentence that will shock the public conscience and has made an error of law as it relates to the sentencing, the prosecution in the appropriate case, the right of appeal would allow us to appeal. Therefore, rebalancing the equity in terms of the interest of justice as it relates to the victim and the particular act of the accused that would have caused the victim's rights to be breached, according to the criminal law.
Understood.
So it's a principle. It is a principle. And this principle of a right of appeal, it transcends personalities. It is a natural part of the evolutionary process in any modern justice system. And alas, Jamaica is perhaps one of the last jurisdictions in the Commonwealth to embrace this principle.